Your patent sucks because your invention is obvious, part 2. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. Hey, if you like this content, please do me a favor and like, follow, and share. This is the second of a 2-part video series on protecting your patent applications and patents from obviousness challenges. I described the basics of the law in the last video. Let me explain an example of how this goes. So there was a case where there was a claimed invention that was basically a computerized device. It had a processor, the elements of a computer, where a child could, on a screen, select a letter, and then the computer program running would play some sort of audio file so the child could hear that letter, right? So it's a way of associating the visual idea of the letter with the sound that corresponds to the letter. The primary piece of prior art was not computerized. It didn't have a processor, as was recited in the particular patent claim. It was electromechanical, but the child could press like a physical button that corresponded to a letter, and then somehow through a series of switches, I suppose, some audio file was triggered, or some audio was triggered to play that letter back. But it wasn't computerized. There was no processor. These claims had the processor and the elements of a computer in it. And then there was another piece of prior art that was basically some sort of reading application that was fully computerized. And so the question was, would it have been obvious to take that electromechanical device and have this method of basically, associating the visual letter with the sound it makes, and then do that in a computerized method, given that fact that this reading applications generally were going in the computerized direction? And ultimately, the answer to that in the Federal Circuit was yes. And so that's the way an obviousness rejection is typically put together, or an obvious attack if it's an issued patent. But there's basically 2 key things that are at issue when you have an obviousness rejection or attack. The first is, do the pieces of prior art that are relied upon collectively teach all of the elements in the claim? Okay? They have to teach all the elements in the claim collectively. And the second is, and this is where it gets murky, would somebody of ordinary skill in the art had some reason or motivation to put those pieces of prior art together, or sometimes it's just modifying a single piece of prior art, but would there have been, was there some teaching in a piece of prior art? Was there a market force? Was there a design incentive? But something that would have led them to put these things together as you have in your claim. And so in the next video, I'm going to discuss more about what you can do to head off that sort of challenge. I hope this helps to keep you out of trouble, and I hope to see you here soon.